Hello everyone, welcome to Kamadhenu Law Academy. We are discussing on the subject constitutional law and we are in the fourth question. Okay, we have completed 3 questions. We are in fourth question. This is very lengthy because we are going to define what is constitution and what are the kinds of constitution. See, why we need constitution? You know, why we need constitution? See, why we need constitution is we have separate rules and regulation for each games, like for football, volleyball, play, whatever games you have, chess, you have separate rules and regulations in that game, and according to that players will be winning or prized according to that. So to look after the citizens and their behavior and to keep the public order in the society, constitution was made. So we are going to define constitution. Who all defined constitution? We will see Aristotle, we will see Geldrick. Constitution is the way in which citizens who are the competent parts of the state are arranged in relation to one another. Constitution is a body of judicial rules which determine the supreme organs of state, prescribes their modes of creation, their mutual relation, their spheres of action, fundamental place of each of them, and their relation to state. Constitution of a state is that body of rules or laws, written or unwritten, which determine the organization of the government, the distribution of powers to the various organs of the government, and the general principles on which these powers are to be exercised. We have kinds of constitution. Written constitution. A book or a collection of documents assembled into a single volume is referred to as a written constitution. It is a purposefully written and implemented constitution. It is created and approved by legislature, council or constituent assembly. According to Garner, a written constitution is consciously planned constitution formulated and adopted by deliberate actions of a constituent assembly or a convention, establishes a clear framework for government institutions including their structures, authorities, roles and interactions. The term written constitution refers to constitution that is composed of book or collection of document. It is purposefully written and implemented constitution. It is created and approved by legislature, council or constituent assembly. Garner writes, a written constitution is a consciously planned constitution formulated and adopted by deliberate actions of the constituent assembly or a convention. It establishes a clear framework for government institutions, including their structure, authorities, roles, and interactions. It represents the state constitutional law. It takes pleasure in its position of supremacy. Its requirements bind the government completely and it operates strictly in compliance with them. The only way to alter a written constitution is to follow the established amendment procedure specified in the document. The constitution was duly passed and put into effect. A written, codified or documentary constitution is one that outlines the fundamental laws of the state in one or more papers, with or without modification. Written constitution have their roots in the French Revolution, the American War of Independence, example India, United States, Germany, Japan, Canada, France, Switzerland. Now we are getting into unwritten constitution. Instead, Britain has a collection of different laws, customs, political practices and court rulings, treaties, and can be found in several different documents that together make up a British constitution. The constitution of this nation is made up of a number of historical records, laws, decrees, customs, traditions and legal rights. Sorry, this is legal. A constitution that has been drafted, adopted by Constituent Assembly or even published in book form is said to be unwritten. Numerous historical charters, statutes and agreements contain it. It is the result of slow, steady evolution. The government is set up and operates according to a number of established but not entirely documented laws and customs. An unwritten constitution is not entirely unwritten, although some of its components are written down, they are not codified in a book, code or legal document. Garner states that an unwritten constitution is one which is the most and not all rules are unwritten and these are not found in any one character or document, example Israel, New Zealand or United Kingdom. Now we will go to on the basis of amendments. Flexible. Ours is both rigid and flexible constitution because we have amendment procedure, both rigid and flexible. We have simple majority, special majority with ratification of state. Okay. So we have both flexible and rigid constitution. A constitution that is easily amendable is said to be flexible. A number of political scientists support the idea that a flexible constitution allows for amendments just like any other ordinary statute. The same process that is used to pass regular laws is also used to pass constitutional amendments. One of the best examples for constitution which is flexible in nature is British Constitution with a simple majority. The British Parliament, a sovereign body, can enact or alter any legislation, even constitutional laws. Laws that seek to amend any ordinary law or a constitutional law must pass using the same parliamentary process, which is a simple majority of legislative votes. A flexible or elastic constitution is one that is easily amendable. These are typically unwritten constitution with a few or no particular amendment procedures. Through regular legislative procedures, the Parliament can change fundamental principles and establish new guidelines for the government action. As shown in the Constitution of the UK and Canada, if a constitution allows for the straightforward amending process, it is considered as flexible. It means that if the bill proposing an amendment is approved by a simple majority of the members in each house who are present and voting, and if the president or governor, as the case may be, signs into the constitution will be amended. Example, Great Britain, New Zealand, Israel. Rigid constitution. The rigid constitution is one that is difficult to change. Its amendment process is challenging. The legislature must approve an amendment bill by a certain typically large majority of 2/3 and 3/4 in order to change it. Ordinary laws are typically passed by the legislature with the support of simple majority of its members. The most basic law of the land is regarded as strict constitution. It is considered to be the fundamental desire of the sovereign people. Because of this, it may only be changed through a unique process that calls for a large majority of votes approve the proposed modification, which is frequently followed by popular ratification in referendum. A rigid or inelastic constitution is one that is difficult to change. These are typically written constitution. Furthermore, it is a constitution whose provision may only be changed through specific amendment procedures and not through regular forms of legislation. In other words, it might be feasible to change constitution if it specifically allows for that change. Amendment to a rigid constitution necessitates a unique, inherent and more technical process. For instance, a majority of the members in both the House, 2/3 majority of the members present and voting are required to adopt some sections of the Indian Constitution such as 54 and 55 prior to being submitted for the President's approval. It must also be approved by at least half of the state legislature. Example, United States, Germany, Australia, India. On power distribution, federal constitution. A federal constitution establishes a separation of powers between federal government and each state. The constituent document will explicitly outline the authority allocation between federal government and the states or the provinces. According to Professor Whereas federalism is the process of allocating authority so that the national and local governments are individually autonomous, unified, and within a sphere. A federal constitution allows for the partition or distribution of powers between union and central and unit states government. This is because both federal and regional governments are independent in their domains and do not share authority. Example, United States, India, Germany, and Canada. Essential characteristics of federal constitution. Supreme constitution, written constitution, rigid constitution, distribution of power, independent judiciary. So, a unitary constitution is one which all powers are vested in single central government. The central government is subservient of the state, provincial, and union governments. For instance, Great Britain. The Parliament has the authority to create new states, change the states' borders, or expand or contract the seas of existing states, Therefore, the parliament is an essential to states' fundamental existence. 3 categories of crisis may be declared by the Union Parliament: financial emergencies, war-related emergencies. The Union government may become unitary as a result of this parliamentary power. Regarding the issues included in the state list, the Parliament passes laws that apply to all or any portion of Indian territory. The Parliament may pass laws in the states listed under Article 249. The 42nd Amendment gives the Union Parliament more authority in relation to tribunal. United Kingdom, France, Japan. Example: United Kingdom, France, Japan, China. Evolved Constitution. Okay. Now you have an evolved constitution is one that has never been created by an institution or by group of people. It is outcome of slow and steady evolutionary process. Its laws and principles are generally obligated since they are acknowledged as time-tested, old historical and accepted practices and conventions. While some of these norms are recognized by the law and some become enforceable, others are adhered to because of their moral commitment, practical usefulness, and public acceptance. The result of historical development, political demands, and people's practical wisdoms are evolved constitution. Like for example, you have UK, New Zealand, Israel, Canada enacted constitution. Next one, a constitution that has been enacted in one of the way that was created by humans. An assembly or council known as constituent assembly creates, enacts, and adopts it. After careful consideration of its goals, tenets, and provisions, it's officially passed. It is written systematically and formally, either as a book or a collection of documents. Example: China, Japan, India, United States. Important features of enacted constitution: an established constitution is codified in a single written text that has been formally adopted through a legislative procedure. They are often created and adopted by constituent assembly or specific legislative body tasked with drafting the constitution. These constitutions go into great detail about the process of drafting, enforcing law, individual rights and responsibilities, and the composition and functions of the government. The enacted constitution, which is considered the supreme law of the land, must guide all legislature and government actions. Enacted constitution contains specific provisions outlining the amending procedure, which can range from somewhat straightforward to extremely complex. Republican constitution: the head of the state is enacted or appointed officially rather than a hereditary monarchy, in which the characteristics of a republican constitution. This kind of constitution generates that the people and the representative retain sovereignty. Important characteristics of republican constitution are: the electoral elects the president or representative either directly or indirectly through an electoral body. Accountability and representation are therefore guaranteed. The constitution upholds the idea that people are the source of all power. This is frequently stated in the fundamental provisions of preamble. Representative democracy makes sure that government reflects the interest and will it constitutes by the electing representative to the government. According to the constitution, everyone is bound by law, even public servants. This contains safeguards against power misuse such as checks and balances. To guarantee that no one has unlimited power, the executive, legislative, and judiciary branches have a clear separation of duties. Citizens are guaranteed certain fundamental freedoms and rights under the constitution, which are upheld by the legal system and subject to judicial enforcement. Example: India, US, France, Germany. Monarchy constitution: a monarchy constitution is one in which a king, queen, or emperor who usually inherits their position by birthright rules a nation. There are various kinds of monarchy: constitution for absolute monarchy, in which king or queen has almost unrestricted authority; constitutional monarchies, in which the king or queen's authority is constrained by a formal constitution or by the law. Types of monarchy constitution. Absolute monarchy. The monarchy has almost total control over the government, is not bound by a constitution or laws. The monarch's word is law and they often control all branches of government. Example, Saudi Arabia. Constitutional monarchy usually acting as ceremonial heads of the state. The monarchy's authority is constrained by laws and or a constitution. In a parliamentary system, elected officials hold the actual political authority. Example, Sweden, Japan and the UK. Based on sovereignty. Presidential constitution. Under the presidential constitution, presidential constitution. Under presidential constitution, the president, who is usually chosen independently of the legislature, is both the head of the state and the head of the government. The distinct divisions of authority between the legislative, executive and judicial institutions is that what distinguishes this type of constitution. Essential elements of presidential constitution. The president has a separate executive power, is chosen separately from the legislature. The president often has set term and it's difficult for legislatures to remove from the office. The three branches are the judicial, legislative and executive. To avoid misuse, each branch functions autonomously and restrains the authority of the others. For a set of time, the president and other important leaders provide stability, continuity in the government. A direct mandate from the electoral is ensured by the president's frequent direct election by the people. Although a legislative supermajority frequently overrides, his president normally has the authority to vote legislation passed by the legislature. Example, US, Brazil, Mexico. Parliament constitution. Executive branch is directly answerable to legislative and receive its legitimacy from it under a parliamentary constitution. This type of government combines legislative and executive branches and frequently had as a ceremonial head of the state, like the president or king, who has few powers. Important characteristics of parliamentary constitution are the legislative and the executive branches are combined in constraint to the presidential system. Members of the legislature, usually the prime minister, are the head of the state and are backed by the majority of the parliament. The parliament is the ultimate authority for the prime minister and the cabinet. A vote of no confidence has power to remove someone from the office. The executive is frequently made up for several people, which results in shared duties and group decision making. Unlike the set of presidential term, governments can be dissolved and new elections held in the incumbent party loses the support of the parliament. This allows more flexible governance. Example, UK, India, Canada, Australia. Conclusion. To sum up, constitution are foundation of the country's legal and political sense. They establish the framework of governance, safeguard the rights of its citizens and uphold the rule of law. They are essentials to preserving national cohesion, promoting political stability and facilitating democratic process. Written and unwritten, flexible and rigid, federal and unitary, republican, monarchical and other constitutional variants reflect the various ways that nations have organized their governance to suit their own historical culture and social requirements. Although each style has advantages and disadvantages, they all strive to build a cohesive, well-functional society with open, responsible and just governance. Constitutions continue to be crucial for directing and uploading countries all over the world, whether they offer a precise codified document like US Constitution or developed through laws and conventions like the UK Constitution. Thank you. Please do subscribe for Kamadhenu Law Academy.